So this so let's see the brief definition here. We can say that intellectual property rights can be created using a brain, resources, labor. Like a normal property can be created using a labor and resources. Suppose you want a car, you have to earn money by using some hard work. So likewise, you have to create your intellectual property using the brain. So here we are, it is indicated in red. That means this is the main ingredients in this creation of intellectual property rights. Importance and significance of intellectual property rights. Like a tangible property can be protected by registering itself in a registration office. You have to protect your intellectual property right in IP India website, which is in patent office. We are having 4 branches in our India, like Mumbai, Chennai, Kolkata, and Delhi. And likewise, we have to protect our intellectual property rights by going to patent office website or directly by physical mode of paying. So in this protection, what you are doing is you are stopping others from using your intellectual properties. So like if you are having your own house, you are not allowing any other people to use your own house until and unless you are giving your permission. Likewise, if you are having your invention, you can give license or assign. In trademark also, you can assign or you can give exchange of your trademark. In exchange of that, you are getting royalty. So in this, by protecting your invention in a registration office and by excluding others from making your invention, stopping the others from using this, you are protecting your invention so that by using these two things, utilize or commercialize your invention. So how to utilize and how to commercialize your intellectual property rights. So these are the 4 things by which you can utilize and commercialization of your intellectual property rights can be done. So if you have any invention, if you have any trademark over here, so you can use this for your own business purpose. Like if you have any business logo trademark, you can use this. You're saying that this is my brand. So this may be useful for your own use, or else here we can say that licensing or assigning. Here, if your invention is there, if you're having your invention, you can license the invention to other persons. Okay, in order to commercialize, in order to get money. Suppose you have invented one a mobile phone, okay, mobile phone charger, which is capable of charging the mobile phone within 2 to 3 minutes. So that is your device. So for that you have put lot of efforts, like you have your intelligence and you put your resources and you put your labor. So you put your time also. Next, you want to sell the product. So how to sell the product? There are 2 ways. Like you can give license to other person, to other companies. In exchange of what? Depending on some terms and conditions, you are giving the license. You are giving your product to your product to do the product. So in exchange of you are getting some royalty. And the same way, if you don't know how to commercialize this, you are going to assigning that product so that the other people can commercialize it. So these are the different things. Take the you can compare this with your car, if your own house. Okay, if you are giving your home for a particular rent, that is not we can call it as licensing. Here we can compare this license with rent and assigning with selling. Okay, if you want completely assign your invention to other people, they will use your invention. Otherwise, depending on some terms and condition, they will use your invention. So likewise, franchising, the best example for this is KFC. Okay, what he did, the owner of the KFC, what he did, he sold the what is trademark, the trade secret of KFC he sold. For in exchange of that, he is getting some royalty. Okay, and at the same time, Disney, you are selling your trademark to commercialize the products. Okay, on every T-shirt we are having Disney logo, and any on any cake. So what they do? In exchange of some money royalty, they are using the trademark. So these are the different things by which you can commercialize your product, your inventions. So create your intellectual properties and you can earn. So how a common person and businessman can get benefit from intellectual property rights? Suppose you have 7 to 8 inventions on your name. It says that this is a social status. You can say that I have this much inventions on my name. So this indicates your pride. So academics means the new educational policy is encouraging inventions and research. Okay, in order to get promotions, you should have at least a research paper or any invention on your name. And a businessman can commercialize the inventions by giving licensing and assignment, and he may have his brand value. Okay, and other thing is that by using his this brand value, he can earn and invest. So first thing we discuss in the intellectual property rights is patents. So patents are related to inventions. Patents are related to inventions, any new technology, any new invention, we call it as patents, and these are all protected under patents. Okay. Any person, they start inventing, they will do lots of research, they will put lots of efforts, they will use lots of resources. Okay. At the end of the invention, what they do, in order to encourage the invention, in order to encourage the research in India, our Indian government has granted patents to the owner, okay, for a particular period of time. So that's why he may get financial benefit and the invention will be having commercial value. So let's discuss what is a patent according to our Indian Patent Act. So we are going to disclose or define the long definition. We may get confused. So let me elaborate the few important things about this. So patent is a territorial right here. First thing we have to remember is patent is a territorial right. This is given to a particular state or particular country. Suppose you are applying a patent in India, that means that patent is related to India only. That means if you are using a that we have created an invention means you can stop others from making, using, selling, offering for sale in India only. You cannot stop others from making these. You cannot stop your rights over the other people or other countries. So if you want to protect your invention in other countries, you can protect it by using PCT or convention method. And exclusive right to stop others from making, using, exercising, vending or importing. So according to section 45 of Indian Patent Act, sorry, section 48. According to section 48 of Indian Patent Act, inventor will get five types of patent rights. Okay, what are the rights? He can stop others from making, using. Actually, this is selling and offering for selling and importing. Okay, exercising means selling and vending means offering for selling and importing. These are the five types of rights a patentee may get. Okay, he can stop others from, because why we are doing these five acts means if we do if anyone copies his invention, if anyone use the invention, he will lose the financial values. Okay, so but this invention and this patent is for a limited period of time. Okay, any invention should balance the interest of the patentee and interest of the consumers. It should not be monopolized. Okay, people should not bother about the price of the invention. Okay, after 20-year periods, the patent will be off patent and anyone can use the invention, anyone can sell the invention. So according to in Latin words, patent means to disclose. Patent means to disclose. You have to disclose everything about your patent, your invention, in a complete specification. Then only in exchange of that you are getting patent. Okay, we'll show the complete specification in this. Okay, here you are excluding others from using your invention. Owner has a qualified right to use the So let's see the main definitions according to Patent Act. We know that patent is given to invention. So what is invention? We have to know is, unless and until we know what is the meaning of invention, and we cannot make the proper research. So for that we have to do some proper research, so that you may get idea of what is invention. So according to section 2(1)(j) of Indian Patent Act, patent means a new product. Invention means a new product or process. Any new product may get invention, maybe invention. Any new process is also called as invention. But it should involve three criteria. It should meet three criteria, that is novelty, inventive step, and capable of industrial application. Here we can say that new means novelty. It should be novel, it should be inventive step, it should be capable of industrial application. And according to section 21L, we'll have in the definition of what is new here. What is the meaning of new here? We are saying. So new invention, what is new invention means? See, when you are getting patent, your patent is limited to particular country. But when your patent is searching, you have to search the novelty of your invention through all over the India. So that's the thing here we are discussing. So new invention should be new, novel in the sense of worldwide novelty is there. So it should not form part of the prior art, and should not be published anywhere in the country or elsewhere in the world. Okay, so it should be novel in the sense of the world. Okay, and here we are having what is the definition of inventive step is discussed in section 21(j) of Indian Patent Act. So inventive step is nothing but feature of an invention. Feature of an invention that involves technical advancements. See, you may wonder that invention means we have to do some lots of study. We will have to do lots of research on that. Then only we should get a patented invention. It's not like that. So many small children also did inventions. They also successful in getting patents. So what they did, and so many old people also got invention above 60 years, like KFC. So what they did, so we have to think about it. So inventive step here means it should be a feature of invention. It should be uh, technical advance compared to existing knowledge. Existing knowledge, if you are improving existing knowledge such a way that they should be having economic significance or technical advancement. There should be technical advancement on that. Suppose we have said that mobile charger, already mobile charger is existing there. What you did, you did some modification in such a way that it has shown some technical advancements. Same way, we have reduced the cost of buying a mobile charger means, so you also reduce the cost. So you reduce the resources required to develop a mobile charger. So that is the new thing. So which has also helped so lots of people. In invention should encourage humans to use the invention. So which should be useful for the customers also. And at last, we are having capable of industrial application. If the invention is like that, it is not being capable of made in the industry, we cannot get patent over that. In invention should be capable of made or used in the invention. This is the invention definition given in the Indian Patent Act. So in the Patent Act, it is also defined that capable of Indian application means capable of being made or used in the industry. It should made in the industry. It should be made used in the industry. Okay. So it should be made in the industry, and it should be also useful in the industry also. So these are the main criteria before you are going to do any research, before you are going to do any technical thing, any invention also. But all inventions are not patentable. You have to keep in mind. So what are the invention not patentable? The patents, the invention which falls in the category of section 3 and section 4 are not patentable. So, and which is not having novelty, utility, and non-obvious is not patentable. So public interest is main. We have to think. Okay. Likewise, the drugs. If you have created drugs so that they are having lots of cost, so they are also not patentable. So briefly, we'll discuss that atomic energy is not patentable. Atomic energy, if an invention is related defense purpose, it is not patentable. So this is a famous invention, first invented patent in our India. This what we call it as an efficient panka pulling machine. So we'll see here what is this. So you can understand what was the difficulty in the past British rule. So panka pulling walas are used to make the room cool by using these strips, long strips. So to necessity is the mother of invention. So the invention is reduce the work of this panka pulling wala using this automatic panka pulling machine. Okay. In 1856, George Alfred Penning was invented panka pulling machine. So one interesting fact about this invention is that he was the first patent agent of the India. The patent number for this panka pulling machine is patent number 1. Likewise, we can see that scientists and inventions like Thomas Alva Edison, along with some other person, invented electric bulb. We know that, and he also invented phonograph. Alexander Graham Bell invented telephone. This is also having patent for this. Wright brothers aeroplane. There is a patent for this. And Louis Pasteur rabies vaccination. Alexander Fleming penicillin. So we are having a famous Indian inventions and these are all patented. So this is a nano car and hepatitis vaccine, Jaipur food. Remember one thing, you have to, your invention should be, whenever there is a mismatch and there is a balance, there is not a balance between interest of the inventor and interest of the persons, then government may involve in the invention. Okay. Suppose one of the case of the India is a Novartis case, that is Nexus Novartis versus Bayer's case, which is given compulsory license to cancer drug. So because Bayer's has increased the price of the Nexavar, which is a drug useful for treatment of cancer, the Indian government has involved in this production of Bayer's Nexavar drug and given NATCO a compulsory license. So first you have to, our Indian government has issued only one compulsory license, that was the Nexavar drug prepared by Bayer's. Okay. Likewise, if the patent is related to drugs and that is related to human health issues, we can get patent for that. Like patent for so these are the famous kinds of patents. So like we are having a so these all drone and a scanner, a sixth sense technology, and a cap may also eligible for getting patent. Patent application filing. So whenever you are going to apply for a patent, you can apply using Form 1, which is application for patent, and Form 2, which is comprising details of your invention like provisional and complete specification. Form 3, okay, which is if you want to file your invention in a foreign country, which this Form 3 is useful. And Form 5, this is very important form. You have to give along with your Form 1 and Form 2, that is a declaration of inventorship. And Form 18, that is a request for examination, shall be filed within 48 months. So you can also expedite your examination process using some, if you are eligible under different kind of categories. Okay, this is the fees for e-filing in rupees. Like Form 1 is 1600, and other natural persons they have to pay 8,000. Form 2, there is no fee for Form 2 because we are filing Form 1 along with Form 2. Up to 30 pages, you are not getting any. There is no any price. If you are getting, if your invention is having more than 30 pages and more than 10 claims, then we have to pay for each page. We have to pay some money. In Form 3 and 5, Form 5, there is no 5 and we are having Form 18. For natural person, it is 4,000. For other person, it is 20,000. Okay. Filing procedure. Let's see here in India website. So this is IP India, ipindia.gov.in. You have to go. If you want to file your patent, this is comprehensive e-filing is there. In here you can file e-filing of patents, e-filing of trademarks, e-filing of designs, e-filing of geographical indications. Here we are having e-filing of patents. Server is little bit busy. Okay, here you can file using comprehensive filing. This is a public search of patents. So you can search the patents which is granted or published. So you can search by using date of grant or date of publication date and priority date. So we can search by date of grant. So we'll see what are the patents which are granted from January 1st to February 1st to April 1st. We'll see here. And you can select the logical operator here. So this is very important when you are doing parrot search in order to do research. Okay. If you are in field of invention is different, you can search. We'll see how to do patent search in, depending on field of search. So these are the different inventions with title and application number. This is application date and status granted. So these are the registered, e-registered, and application status. So here, system for detecting type of sleep disorders and method of operating thereof. So we'll see here. This is a e-register. See, this is a patent number and date of patent is 6/9/2022. Date of grant is 21/3/2023. Date of filing is the date of patent. Okay. Here, the type of application is ordinary application, and because if they are not filing in foreign countries, so this is ordinary application. Date of recorder is 21 March 2023. So appropriate office is Mumbai. So here are the name of the grantee and grantee type. These are all natural persons. So here we can have annual amount fees 800. So till 20 years, they are having their right. So these are all documents we have to submit during the process of getting patent. Okay, you have to give your full details, including your claims also. So this is patent certificates. So this is a patent certificate which include patent number and application number and date of filing. Date of filing is the date of patent. From the filing of date itself, your patent lifetime starts. From the date of filing till 20 years, you were having your lifetime. That means 20 years mean 2042. Okay. Here they are mentioned that it is hereby certified that a patent has been granted to the patentee for an invention entitled System for Detecting Type of Sleep Disorders and Method of Operating thereof, as disclosed in the above mentioned application for the term of 20 years from the 6th day of September 2022, in accordance with the provisions of the Patents Act. So here the grant is on 23rd 21st March 2023. So you have to remember one thing is that your filing date only the date of patent. So you have to disclose everything in the complete specification. So this is a complete specification. In this you have to mention the field of invention and background of the invention. What is the problem of your invention? You have to discuss the what are the problem faced in the previous days before your invention is invented. Okay, depending on that problems you have created your invention. So this is the object of the invention only shows your summary of the invention, and the object of the invention shows the solution you have solved in this invention. So brief description of the drawings and detailed description of the invention disclose how the invention, how the device is technically connected. Okay. So in this you have to mention best method of performing your invention. All things you have to mention such a way that a average skilled person, suppose this is related electronics, so electronic related person can do these things by reading this complete specification. So here he's mentioned the type disorders. So everything you have to mention in the patent specification. So he's disclosed the claims also, and at the end he disclosed the abstract, which is indicating the brief idea of your invention. So these are the inventions and their specifications. You have to do form and drawings also you have to mention. So here they are having all things. So the invention relating to DRDO and atomic energy related inventions are not patentable. The thing we have showing there in showing this. So the central government will decide whether your invention is relating to atomic energy or not. Okay. examination, formal examination and technical examination. So you have, whenever you are applying for a patent, your invention is gone through technical and formal examination. Formal examination means whether there is any fee payment is due or not. Technical examination is this is checked under patent acts and rules, whether it is according to patent acts and rules or not. Novelty search, all are mentioned here. So you have to reply to the objection raised by the controller. If you fail to give objections on time, your patent will be withdrawn or abandoned. So this is a technical examination. So there is a certain timeline is given. Okay. Whenever your invention is 70% complete, you are going to apply in provisional specification. After completion of your invention, you can within 12 months, you can submit your complete specification within 12 months. You can submit request for examination. You can submit request for examination within 48 months from the reply to FER. You can give reply to FER within 6 months. You can give Form 3 within 6 months from the application date. You can give Form 5 within 1 month. And withdrawal of application is 15 months. That means your application is submitted, published. Okay. Whenever you have given any specification, your specification is published in the patent office journal. Each Friday, your patent specification is published. Okay. Within 15 months of your application, you can withdraw your application. Okay. Hearing submission, you have to request for hearing within 15 days from the giving of objection by controller. And any person can apply for a patent opposition. And after 1 year, within 1 year from the grant of patent also, any person interested, only person interested becoming the opponent party can represent as a post grant opposition. Okay. But after 1 year, no one can raise objection on your invention. Here we are going to designs. So Design Acts came into 2000 and rules came into force in 2001. So according to Design Act, design means only the creature of shapes, but here configuration, pattern, ornament or composition of lines or colors. Remember one thing here, designs are ornamental compositions. That means they are solely judged by our eyes. Okay, there is nothing to do with the technical aspects of the designs. If you have invented any safety pin also, the design is different from the previous one, we can also get patent from for that. Okay, if you have any invented any water bottle which is having a design different from the previous one, we can have design patent for that. So why we are selecting for we are protecting designer. Suppose one girl has made necklace. Okay. She struggled for so many years and she did a beautiful necklace and beautiful handbag. So she want to protect that because this is my intelligence which has created this beautiful design. Okay. She is going to design patent office and she is protecting her design. Okay. Because no one can make the design, no one can copy the design, so that she can earn the rights of the design. Okay. Likewise, any person creating the design using his creativity. Water bottles are different kinds of water bottles are there. If you want to protect, if you want to choose one of the water bottle, depending on the size, depending on the color, depending on the design, you are selecting the color. Selecting the water bottle. So here, this is the main criteria behind the designs. So designs may be anything which is a feature of the shape, configuration, pattern. Pattern, we can say that on saris we are having a pattern is there. So for that also we are having design, ornament or composition of lines. Okay. So here we can say the term of design is 10 years. For 10 years you can protect your design. After 10 years you have to give renewal fee. Okay, so that design is protected for more 5 years, and after 5 years you cannot extend your time for designs. The overall period for design is 15 years. So according to Designs Act, Section 2A, article means any article of manufacture in any substance, article or partly artificial. So any article, it should not be completely natural. Okay, completely natural means you have not done anything. So it should be partially natural or partially artificial or completely artificial also can consider under article under Section 2A. So, what is original design here? In relation to the designs, originate means originating from the author of such design and includes the cases which thought old in themselves, yet they are new in their application. Okay. Uh, Suppose we are considering the safety pins and water bottles. The functioning of the water bottle is same, but if you have changed the design, okay, if you have changed the, if you have suppose a 5 years old boy, what he did, he has replaced the cap with a water taps mop, and he attached that with a the water bottles, okay, nib. So that is a different kind of a cap. Okay, to drink water, that is a different kind of design is there. Okay, so many water bottles are having different kinds of shape. Depending on the shape only, they are getting design shape. So these are the different shapes, different designs: a sofa set, hand wash container, and a mask, and a machine, a cycle, and a watch. So here having set of articles may also get design protection under Rule 2E. Design of article set means any ornament, any tea set, any sofa set. So main design office is Kolkata, and you can go directly by going to patent office. But remember one thing: filing fee for physical filing is 10% more than online filing. So there are 4 branches: Kolkata, Mumbai, and Chennai. So and electronic processing module is IPO Kolkata. So there we will do examination and registration, publication of post registration of designs. So the application fee for individual is 1,000 rupees. For small entity startup, now it is small entities. For small entities startup is now it is 2,000, and for companies it is 4,000. So application form includes applicant full names, nationality, address, class number, priority data, prior registration, prior signature dates. So you have to do simple. You have to represent two representations illustrating various views of your article. And if you are submitting your application using patent attorney and patent agent, you have to submit form 21. So if you are going to assign your invention to other companies or persons, okay, you can do so by using assignment document. So if the person is small entity or startup, you can submit form 24. Here is the perspective view of the design. So you have to represent the design by using this perspective view. This is a certificate of the design. Here, this is a publication. How much time we are having only? Few time is there. Okay. Before delivery on sale of any article to which registered, so you have to see the design is registered. You have to see REGD or RD on the registration number, except for textile goods and retail article. So next intellectual property rights is trademarks. So according to Trademarks Act 1999, a trademark according to is it is a graphical representation. Okay. But other countries will accept like what smell music. Like Nokia is having a music trademark. It is a sound. Okay. So, but our India is not having that. Our India is having 2D, two-dimensional representation, three-dimensional representation of, or graphical representations only accepted here. So that may be any word, any name or symbol or device or combination of these things. So it should identify the goods. Okay. So how trademark should be means, it should identify. Suppose you have designed a new t-shirts, you can give a brand to the t-shirt using some logo or any value, brand name, but it should indicate your brand name, and it should not mislead the customers. Okay, it should not mislead. And this provides exclusive monopoly over a class of goods or services. So, whenever you are applying for a trademark, your trademark product or goods and services will get trademarks. Your trademarks, goods or services will be examined. They will see whether your invention is whether your trade goods or services, your trademark is unique or not, whether the product is genuine or not. So each and everything they are going to consider. So that product which is having trademark is a genuine product. Okay, we'll say branded t-shirt, branded. Why they are having that much importance means they are undergone each and every stage of examination is gone through that product. Okay. Identify the source or origin of goods or services, assures customers about quality of goods or services. So whenever you are using you are purchasing any article, goods or services, you have to check whether they are registered under trademark or not. So these are the different types of goods or services we are having trademarks. So they can be including service marks, trade names, collective marks, certification marks, taglines, slogans, shapes, sound marks. So here we can say that this is what's this is this is word mark, and this is letter. This is a letter mark. This is word mark, and this is a combination mark because this is a symbol and this is word. This is a symbol mark and this is a word mark, and this is certification mark. This is a logo. This is service mark which is providing Naukaris. That means Naukari.com. Dil Mange More Pepsi, and Bureau of Indian Standards. This is certification marks, and Columbia. This is also gives certificates to movies. So this is also certification marks. So a good trademark, what a good trademark means, it should inherent from the product. It should represent what is the product is, and it should acquire from the product, but it should not mislead the customers, and it should not be honestly coined. It should not be represented or cheated, because it should not copy other trademark. So remember one thing, whenever there is a product which is having R circled, then we can say that which is registered under trademark, which is that if the product is having TM only, we can say that this is registered, this is not registered under trademark, but because the application pending under trademark, we can say that there is pending application in trademark, but it is not completely trademark. This is a trademarked goods or services. We can say that this is a trademark. Okay. How to protect your trademark? So protection of registration is optional, but whenever you are registering your product in the trademark, it gives assurance to the customers, and your brand, you are earning your brand value. Okay. So registration is available. Simple process is there. Government has made the process of registration very simple. You can go to online, you can apply for a trademark registration. They will do some examinations. After that, you will get if your product is genuine, you will get trademark registered. But the lifetime of trademark is 10 years. If you want your product to be having a trademark, you can renew for every 10 years. That means the lifetime of trademark is indefinite. Here we are having copyrights. What can be copyrighted? Artistic and literary works are copyrighted. Here, suppose if you want to take a movie on Mahatma Gandhi, so anyone can have the idea of taking movie on Mahatma Gandhi. What is the different thing is here? The expression of idea is different. Here, the copyright protects the expression of ideas. Anyone can sing song on Mahatma Gandhi, but they express their ways on different way. Okay, so not lyrics. You cannot copy lyrics. The expression of the way of your expression is different from each person. So we can say that copyright cannot protect an idea, but the expression of ideas can be protected. So that we can having different paintings are there. So a tree can be painted by lots of persons in a different ways. The idea of painting a tree is not a copyrighted, but the idea of the expression of a painting of a tree on a paper is copyrighted. Okay, it should be original. It should be minimum modification should be there. It should be fixed. So the feature Copyright is Act is 1957. So let us see the features of Copyright Act 1957. Here we are having provisions related to Copyright Office and registration of copyrights, provisions for statutory and compulsory licensing of works, and provisions related to the rights of the owners of copyrights and tenure of the protection. So we are having protection related to broadcasting rights and performance rights. So provisions related to infringement and remedies. So these are the different works which are protected under copyrights. We are saying, simply we are saying artistic and different works. Remember one thing, not only artistic and literary work, but also databases and software can also consider copyright. As we said, a user manual, which is relating to a software product, that can be copyrightable. Okay, so any software program independently can be copyrighted, and if it is doing work along with the hardware, then it can be patented. So in according to section 2L of Patent Act, only computer program per se are not patentable. That means only person means only computer programs are not patentable, but if they are having any technical effect, they can be patentable. So we can understand that softwares are patentable, softwares are copyrightable. So literary works according to section 2, literary works, dramatic work according to section 2H, sound recording works according to 210 220, artistic works according to section 2C, musical works according to 2P, cinematographic works according to section 2F. So for literary or dramatic work, the writer is the owner of the copyright. Music work, music composer will be the owner, and artistic works other than photograph, artist will be the owner. And for photograph, the person who is taking the photograph is the owner. For cinematographic work or sound recording work, the producer is the owner. For literary, dramatic, musical or artistic work, which is computer generated, the person who causes the work to be created or owner. But the person who is doing the not the main idea, who is giving the person who is causing the work to be created is the, like animation movie, the producer is having the rights for taking the movie. Rights of authors of copyright works. We can divide the copyrighted works into two rights: economic rights and moral rights. So let us consider these rights with examples. Economic rights we can consider as a books, because if any person is having autobiography of any person like Abdul Kalam, anyone can take a movie on that. So that what we can say, that is economical, that is transferable rights. If the person has given right to take a movie on that, if they can get royalty in exchange of that, and he will get economical rights. And moral rights means, if a person has taken a painting, drawn a painting, if a person has made a sculpture, So with a stone, so the art remains with him only. No one can copy that art. No one can do any modifications to that art. So that comes under moral rights. So copyrighted works can be copyrighted. That means a copyrighted work, there's like a song can be remade. That we can call it as reproduction right. Distribution right. A book can be um, taken as a film. That is a distribution right. Right to create derivative works like cinema, sound recording. Right of communication to public. So replaying of work by distance or interactive communication. And right of public performance. So like public performance of a movie can be like public performance on a novel. Can also be a drama. Can be right of public performance. Okay. So here we can see right against distortion and right of recognition. Okay. Here, the right to object to the work being distorted or used in the context that are prejudicial to the honor and reputation of the author. So moral rights cannot be destructed. No one can copy the moral rights. Okay. So these are the rights against destruction. Anyone, if anyone do that, there will be civil action will be taken. So term of protection. So remember one simple thing is the original copyright works are having 60 years life, 60 years time plus lifetime of the author. Okay. So if any work is redone, that means reproduced, replayed, then they are having less time. So here broadcasting reproduction rights are 25 years from the year of following the year of broadcast, and performance rights depending on a book, if you have taken any movies, then that is 50 years from the year following the year in which performance is made. The form 14 is for application procedure. Each such application can be filed in the copyright office. So using copyright.gov.in website, here this is a piece. Uh, so any copyrighted product is any work is scrutinized and formality check is there, and this is if hearing is done by registered, if they accept then copyright is approved, then otherwise if it is thought that this is a copyrighted work, they will not get copyright. And we are getting semiconductor integrated circuit layout design. Semiconductor integrated circuit, each and every electronic device is having transistors are connected in a different ways, and circuits layouts designs are connected in a different way. So we can protect that by using SICLD Act. Okay. So Delhi is the office where applications on layout designs of integrated circuits are filed for registration of created IPR. So SICLD is an important of IPR for protection of products with fast changing technologies such as electronic gadgets, computers. So the lifetime of SICLD design product is 10 years, and for first commercial whichever is earlier. So 10 years only, but not more than 10 years. So then we can come geographical indications. Athuli Bharati Amuli Nidhi, invaluable treasures of incredible India. So we'll see the video of this in geographical indication once using IP Nani. Ma'am, can you see the video here? Hello?
Hello?
Can you see the video here?
Yes, we can see, but voice is not coming there, ma'am.
I think your voice is not available for
Yes,
this.
voice is not
Is it
coming.
not audible?
No, no, it's not audible.
It's okay. We'll continue. So geographical indications are any product is having a unique qualities depending on the particular area. Okay, Nagpur orange, the taste and the productivity, the quality of the Nagpur orange is due to the origins of the Nagpur orange, like Sholapur chadar and Tirupati laddu. So these are all having different qualities due to the origin of the products. So here the geographical indication, according to Geographical Indication Act, a geographical indication as an indication that identifies a product that have a specific geographical origin and possesses qualities and reputation that are due to that origin. But remember here, the main thing we have to think about this is geographical indication encourage farmers and encourages the products which are originating from our rural India. Okay, so many different qualities are there in our rural India. So in order to encourage the products which are originated from our rural India, so we are providing this Geographical Indication Act. So one of the first geographical indicated product is Darjeeling tea. Okay. Why we are saying Darjeeling tea means Darjeeling tea is the geographical indicated product which is registered in 2004, and this is the first geographical indicated product. Okay. And Makrana marble and Bobbili Veena from Bobbili, Basra Dogra, Venkatagiri handloom saree, Siddipeta Pulabhima, Narayanpet handloom saree, Madurai Malli, Wayanad Jeeraka Sala rice, and Surat Jerry craft, Nagpur orange, Nilgiri tea. So first indication is done by Government of India, rights for limited period of time. And there is no automatic relief is there. Need to file because anyone is taking action. Anyone is stealing your invention or copying his invention. It is not automatically taken action. You have to take action. Okay, you have to protect and you have to fight. Okay, so renewal fee to be paid for some IPRs. Okay. But because patents are not like that, we have to pay renewal fee and it is not expensive. Okay. Mm, Appointment of patent agent is not compulsory. If you are good at drafting, you can do. Career opportunities. We may having government job, examiner of patents and designs, examiner of trademarks and geographical indications, examiner of copyrights, and others are patent agent, trademark agent, JRF and SRF in patent facilitating centers, and patent litigation and other opportunities in private sector. So for any queries, please contact me. And if you have any queries, please ask me. Okay, I will clarify your doubts. And if you are having time, we'll continue with quiz, or else we'll stop the session here itself. Shall I continue now?
Yes, ma'am.
Okay. Can anyone recognize, find the famous trademarks over here? Find the famous trademarks.
Famous
These are not,
trademarks.
mm, these are word maps. You can recognize. This is a puzzle. Anyone can raise their hand and give the answer. Okay. Uh, Here. Shall I reveal the answer? Okay.
Yes,
Here
ma'am.
we have Pepsi, Cadbury, uh, and here we are having Amul, Tata, Dettol, Horlicks, Babool, and Bata. These are famous trademarks. So find the IPR in each figure. So what is the figure 1 represents? What is the type of IP used to protect this figure 1? Can anyone say? What is this figure 1 represents? This is a painting. So to protect this painting, what type of IPR is IP is useful? Copyright. Okay. And figure 2, we are having sculpture. So to protect this artistic work, we are having copyright work. So in figure 3, can anyone say, like I explained in figure 1 and figure 2, can anyone explain figure 3? In figure 3, the logo is given on laptop and for mobile phones, smartphones. So Apple iPhone is shown here and Apple laptop is shown here. So we are having a Apple is similarity here. So we can say that this is a trademark. Okay. And fourth, distillery. This is a word mark. So we can categorize under trademark. And what is figure 5 shows? Coca-Cola. This is also a trademark. Which type of intellectual property protects the painting painted by artist? Can anyone say? Hello? This is copyright. What protects the intellectual property created by fashion designers? I think no one is giving response. Hello? Are you there? Hello?
Hello.
Yes, ma'am. Anyone is listening or anyone is giving answers?
Yes,
This is
please.
designs. What
Design.
protects the advanced disc brake of bike developed by inventors? So this is showing the invention means this is a patent. Which of these is a geographical indication? BMW is a trademark and Nagpur Ramoji is a geographical indication. What does a trademark protect?
आर्ट आर्टला कॉपीराइट म्हणून सांगितलं त्यांना.
So trademark protects logos, names and brands. How long can a patent last? 10 years, 20 years, 40 years or 60 years?
20 years.
20 years. Okay. If you write an original story, what type of intellectual property gives the right to decide who can make and sell the copies of your work?
Copyright.
Okay. Imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can be used to show that clothes are made by his company?
Trademarks.
Yes. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying the invention? Here, the term invention is there. To protect invention, which type of intellectual property rights we are using?
पेटंट.
Okay. Thank you so much, ma'am. And we'll finish the session, end the presentation here. Just
Thank you, ma'am.
we'll meet in Google Meet.
For
Just
throwing light
we are
on intellectual property rights.
ma'am, we are going to take a one pic. Okay, we are going to take one pic.
One video. One video
Uh,
is there, ma'am. Okay.
yes, ma'am. Please, because this is used. Can all of you turn on their video? We'll take one pic. Yeah. Thank you so much, ma'am, for conducting this awareness program. Hope you all got awareness about intellectual property rights. Thank you so much, ma'am.
Thank you, ma'am. Sir, Dr. S.K. Bendekar, sir. Vice Principal Dr. G.S. Wankhede, IQAC Coordinator Dr. Y.V. Somanshu, Dr. S.R. Shinde sir, Dr. S.L. Dive madam, and all senior staff of Baliram Patil College Kinwat. I am thankful to all students who have participated in this webinar. Okay, so this will be end of this session.